Another aspect of commercial mediation is how to reach it. And there are many ways, but now I'd like to turn your attention to the multi-step dispute resolution clauses. What are these? Well, these are contractual provisions obliging the parties to a dispute to opt out for a various form of out-of-court solutions for resolving their conflict following a certain process manner envisaged before the dispute is referred for its final settlement. In other words, these are contractual provisions you have crafted and put into your agreements beforehand, and they actually are providing step A, step B, step C that you need to follow for a resolution of any dispute that you may encounter in the course of the commercial relationship development. Validity of multi-dispute resolution clauses has been a major issue in this field of law because the multi-step dispute resolution clauses should meet three very major criteria. They have to be clear, they have to be precise, they have to provide for time-specific mechanism for resolving a particular dispute. And to give you an example, I'll use the ICC mediation rules, which provide for 4 different types of such clauses, and they differ in between depending on the power that they have on the parties to use mediation or not. So the first one is that the parties may at any time, without prejudice to any other proceedings, seek to settle any dispute arising out of or in connection with the present contract, in accordance with the ICC mediation rules. This actually provides only for an option to use the ICC mediation rules. However, it does not oblige the parties. They are merely reminded of this possibility, but they are not obliged to follow it. The next possible clause to insert in your contracts is the obligation to consider an ICC mediation clause. And it follows like that. In the event of any dispute arising out of or in connection with the present contract, the parties agree, in the first instance, to discuss and consider referring the dispute to ICC mediation rules. Here again, the parties, when encountering a conflict, should consider its resolution through the ICC mediation rules or any other rules that they have chosen prior to the signing of the contract. Then, another clause may be where the parties have previously agreed that they are obliged to use mediation. However, parallel to that, they could initiate arbitration proceedings and run the two simultaneously. A clause like that would provide that in the event of any dispute arising out of or in connection with the contract, the parties shall first refer the dispute to proceedings under the mediation rules of, and here you can put ICC or any other mediation tribunal that you're using, and these proceedings shall not prevent any party from commencing arbitration in accordance with the subclause below. And below you are actually providing your usual arbitration clause. Fourth, and possibly strongest in terms of fortifying a mediation process taking place before arbitration, is a clause where you are barred from lodging any arbitration claim before you have exhausted in full the mediation options. The clause goes as follows. In the event of any dispute arising out of or in connection with the present contracts, the parties shall first refer the dispute to proceedings under the ICC mediation rules. If the dispute has not been settled pursuant to the said rules within, and here you put a given number, let's say 45 days, following the filing of the request to mediation, the parties may agree that such dispute shall thereafter be finally settled under the rules of arbitration of, and here you put your tribunal to which the dispute would be referred to in case no solution is reached during mediation. Mediation is about finding practical solutions to pragmatic problems, and in business, companies are used to do so on a daily basis. Therefore, Their tools, used and practiced so often, should become part of the procedure for a commercial mediation. Thank you.